For this video, we are going to discuss Article 145 of the Revised Penal Code, which is the crime of violation of parliamentary immunity. Article 145, Violation of Parliamentary Immunity. The penalty of prisión mayor shall be imposed upon any person who shall use force, intimidation, threats, or fraud to prevent any member of Congress from attending its meetings or of any of its committees or subcommittees, constitutional commissions or committees or divisions thereof, from expressing his opinions or casting his vote. And the penalty of prisión correccional shall be imposed upon any public officer or employee who shall, while Congress is in regular or special session, arrest or search any member thereof, except in case such member has committed a crime punishable under this code by a penalty higher than prisión mayor. What are then the punishable acts under Article 145? First punishable act, by using force, intimidation, threats, or fraud to prevent any member of Congress from attending its meetings or any of its committees or subcommittees, constitutional commissions or committees or divisions thereof, or from expressing his opinions or casting his vote. Now, to better understand this particular punishable act, let us break down its elements. First element, for this particular punishable act, the offender here can be any person. Take note of that. Second element, the offender uses force or he uses intimidation or threats or fraud for the purpose of, third element, preventing a member of Congress from attending its meetings or of any of its committees or subcommittees, or for the purpose of preventing a member of Congress from attending the meetings of the constitutional commissions or committees or divisions thereof, or for the purpose of preventing a member of Congress from expressing his opinions, or for the purpose of preventing a member of Congress from casting his vote. Now, take note, however, that even if the offender uses force or intimidation or threats or fraud, but not for the purpose of preventing a member of Congress from attending its meetings or from expressing his opinions or from casting his vote, then there is no violation under this article. Is there a crime committed? Yes, but as I said, not under this article. Let's say, for example, the offender uses force to prevent a member of Congress from attending the meeting called by the President in Malacanang. There is no violation under Article 145 here because the meeting in Malacanang held by the President is not among the meetings mentioned in Article 145. That is how specific the third element is in Article 145. Outside of these purposes, there is no violation. So if a member of Congress is prevented through the use of force, then that member of Congress can file a case of grave coercion against the offender or unjust vexation, as the case may be, but not under Article 145. Second punishable act, by arresting or searching any member thereof while Congress is in regular or special session, except in case such member has committed a crime punishable under this code by a penalty higher than prisión mayor. Let us break down its elements. First element for this particular punishable act, the offender this time must be a public officer or employee. Second element, the offender who is a public officer or employee arrests or searches any member of Congress. Third element, that at the time of the arrest or search, Congress is in regular or special session. And fourth element, the member arrested or searched has not committed a crime punishable under the Revised Penal Code by a penalty higher than prison mayor. Now, is there a conflict between Article 145 of the Revised Penal Code and Article 6, Section 11 of the Constitution? To better understand what I am talking about, allow me to read again the second part of Article 145 so that you will know what I mean. And the penalty of prison correctional shall be imposed upon any public officer or employee who shall, while Congress is in regular or special session, arrest or search any member thereof, except in case such member has committed a crime punishable under this code by a penalty higher than prison mayor. Whereas in Article 6, Section 11, it states, and I quote, "A senator or member of the House of Representatives shall, in all offenses punishable by not more than 6 years imprisonment, be privileged from arrest while the Congress is in session. No member shall be questioned nor be held liable in any other place for any speech or debate in the Congress or in any committee thereof." Now, I want you to focus on the first part of Article 6, Section 11, which apparently is in conflict with the second part of Article 145. Why do I say that these two provisions are in conflict with each other? They are in conflict with each other because Article 145 mentions only the Revised Penal Code, crime punishable under this code. Whereas Article 6, Section 11, with respect to the immunity of a member of Congress from arrest, it encompasses not only violations under the Revised Penal Code but all offenses, including violations under special penal laws, because precisely the wordings use the term or the phrase all offenses. Then the second difference, glaring difference, is that in Article 145, Article 145 mentions penalty higher than prison mayor, a crime punishable under this code by a penalty higher than prison mayor, whereas in Article 6, Section 11, it talks about crimes punishable by not more than 6 years imprisonment. So, all of or both of these provisions talk about parliamentary immunity of a member of Congress. In Article 145, a member of Congress is immune from arrest so long as the violation is with reference to a felony under the Revised Penal Code and so long as the crime punishable under the code is a penalty not higher than prison mayor. Whereas in Article 6, Section 11, a member of Congress is immune from arrest so long as the offense, whether from the Revised Penal Code or under special penal laws, does not exceed 6 years imprisonment. So, in other words, there is an apparent conflict between the two provisions. Okay? However, a statute, and you know this in your statutory construction, a statute cannot prevail over the Constitution. Hence, the immunity of a member of Congress from arrest applies to all offenses punishable by not more than 6 years imprisonment. Meaning to say, Article 6, Section 11 on parliamentary immunity of a member of Congress prevails over the provision on parliamentary immunity under Article 145. Now, when is Congress deemed to be in regular or special session? The answer is found in Article 6, Section 15 of the 1987 Constitution, which states, and I quote, "The Congress shall convene once every year on the fourth Monday of July for its regular session, unless a different date is fixed by law, and shall continue to be in session for such number of days as it may determine until 30 days before the opening of its next regular session, exclusive of Saturdays, Sundays, and legal holidays. The President may call a special session at any time." In other words, Congress is deemed to be in regular session every year starting on the fourth Monday of July until 30 days before the opening of the next regular session. When is the next regular session? On the fourth Monday of July. That is constant or fixed. On the other hand, Congress is deemed to be in special session when called upon to do so by the President. Okay? A member of Congress, therefore, cannot be searched or arrested if the following requisites concur. Number one, when Congress is in regular or special session. And number two, if the crime he is alleged to have committed does not exceed 6 years imprisonment. Conversely, a member of Congress can be searched or arrested, letter A, if Congress is not in session, meaning to say Congress is adjourned, even if the crime committed does not exceed 6 years imprisonment. Or letter B, a member of Congress can be searched or arrested if the crime committed is punishable by more than 6 years imprisonment, even if Congress is in session. What is then the scope of parliamentary immunity? There are actually two privileges that a member of Congress enjoys under this term or phrase parliamentary immunity. The first one is the so-called privilege from arrest. Now, this privilege is intended to ensure representation of the constituents by the members of Congress. In Vera versus Avelino, the Supreme Court, quoting a decision of the U.S. Supreme Court, explained for whose benefit the right to parliamentary immunity is secured. This is the particular pronouncement of the Philippine Supreme Court on the nature of this privilege. The Supreme Court said, "These privileges are thus secured not with the intention of protecting the members against prosecutors for their own benefit, but to support the rights of the people, by enabling their representatives to execute the functions of their office without fear of prosecution, civil or criminal." Meaning to say there must be some leeway given to members of Congress so that they can effectively perform their duties as representatives of the people. The second privilege under the phrase parliamentary immunity is the so-called privilege of speech and debate. Members of Congress cannot be prosecuted for any words spoken in debate or in connection with voting or used in written reports or with things generally done in a session of either house in relation to the business before it. This protection is extended to them during the session on the occasion of the exercise of their functions, either in their respective chambers or in joint assembly, or in committees or commission. The purpose of this privilege of speech or debate is not to protect the members against prosecutions for their own benefit, but to enable them as representatives of the people to execute the functions of their office without fear of prosecution, civil or criminal. So the reason is the same, no, as with respect to privilege of or privilege from arrest. As held in the case of Osmena versus Pendatun, its purpose is to enable and encourage a representative of the public to discharge his public trust with firmness and success, for it is indispensably necessary that he should enjoy the fullest liberty of speech, and that he should be protected from the resentment of everyone, however powerful, to whom the exercise of that liberty may occasion. It guarantees the legislator complete freedom of expression without fear of being made responsible in criminal or civil actions before the courts or any other forum outside of the congressional hall. So, what does this mean? Even if the speech made by a member of Congress inside the halls of Congress could be libelous or defamatory, for as long as it is connected with the performance of the functions of his office, he will not be held liable for such crime. Okay? But it does not protect him from responsibility before the legislative body itself whenever his words and conduct are considered by the latter disorderly or unbecoming to a member thereof. So, yes, while a member of Congress enjoys fullest liberty of his freedom of speech for so long as the words uttered by him or spoken by him or written by him are in relation to ongoing legislation or in relation to something that they are investigating, that lawmaker or legislator or member of Congress will not be held liable for libel. However, Congress has the power to discipline such member of Congress for disorderly conduct or disorderly behavior, or whenever his words are considered unbecoming to a member of Congress. So, merong disciplinary authority yung Congress itself to discipline or sanction a member of Congress for showing disorderly behavior or whenever his words tend to diminish the sanctity and value of his office.